So, thank you all for joining us today for this training, Your Keys to Fair Housing. My name is Derek. I will be your presenter today. I am the Director of Education and Outreach here at the Fair Housing Center of Southwest Michigan. I am a white man with red hair and wearing a blue and green shirt in honor of our organizational colors today. And before we get into the bulk of today's presentation, I want to make a brief couple of acknowledgments. First and foremost, we'd like to thank MSHDA, the Michigan State Housing Development Authority. It's through a generous grant from MSHDA that we were able to offer this and the rest of this cycle's trainings free of charge. So a big round of applause for MSHDA. Today's information is for educational purposes only. It's not legal advice. If anything in this training inspires you to act organizationally or personally, always seek the advice of a legal professional before doing so. And finally, the session is being recorded. And that's right. I would also like to say that we do have a Q&A and chat feature on the Zoom Workplace that if you could hold, or rather not hold, but if you have any questions during the presentation, please pop those into the chat or Q&A box, and we will do our best to get to them at the end of the presentation. And the last of our housekeeping is just a little bit about the Fair Housing Center of Southwest Michigan. We serve Allegan, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren counties. Those are the 9 counties of Southwest Michigan. And we promote integration and work to eliminate housing discrimination. And we use 3 tools for this. That's education, advocacy, and enforcement. And we're intentional about that ordering. The Office of Housing and Urban Development estimates that each year there are around 4 million occurrences of housing discrimination, of which only about 11,000 go reported. And so when we say the ordering is intentional, we mean that by first educating well enough, we can ideally eliminate housing discrimination before it begins at the point of the landlord. We can also inspire and encourage people to recognize and report housing discrimination that they may be going through, after which they can bring that up to us. We can advocate on their behalf, and through that advocacy, we can learn which cases merit further enforcement. Our successes and efforts through that enforcement then feed back into our education and help us better calibrate what needs to be focused on in education, and the cycle continues. So we are the Fair Housing Center of Southwest Michigan, but what is fair housing? Put shortly, fair housing is the right to equitable access to housing, and this affects all of the steps of the housing transaction. And we have a incomplete list here. That's renting, selling or buying, advertising, financing, insuring, appraising a house. We're dealing with some client work lately where even if you have a guest come to visit you, that guest and the treatment of that guest is beholden to fair housing law. And the goal of this session is to give you information that will help you protect yourself and the members of your communities. Largely, this training is designed around a tenant perspective. Of course, it's very important that landlords and housing providers are aware of their responsibilities, obligations under fair housing. But this training in particular is geared toward tenants. And you do not have to feel like you need to memorize anything or everything today or leave today as a fair housing expert. We'll offer more trainings throughout this grant cycle, and you can always call us at the Fair Housing Center for any clarifying questions. So another way to say that fair housing is the right to equitable access to housing is to say that you have the right to be free from housing discrimination. And there is a formula that determines whether or not something is housing discrimination. First, it needs to involve a covered dwelling. That is a dwelling that is beholden to the laws of the Fair Housing Act and other associated laws. Very nearly all residential constructions are covered by fair housing. You need to be a protected person or fall into a protected class or characteristic. And federally, there are 7 of these protected classes. You have race, color, religion, national origin, sex, family status, and disability status. Now, state and local governments can add to but never curtail those protections. And each of these protections were won over time and installed into the fair housing law by different legislative victories. And we'll cover that timeline shortly. And finally, there needs to be an unlawful practice. This is something like refusing to sell or rent to a prospective tenant. And that needs to be based, uh, that disallowing needs to be based on the protected class. If all three of these elements are present, you have housing discrimination. And we'll get into each of these a little bit more as we go on. So, covered dwellings or covered housing. You can see again another incomplete list: houses, condominiums, housing, apartments, transitional housing, college residence halls, and dormitories. Under fair housing, a dwelling means more or less the same thing as housing, and it should be considered as having a broad definition as possible. There are some exceptions, of course, but all places a person could make their residence are covered by the Fair Housing Act. Uh, you have things like hotels and motels, which are typically not covered by fair housing. And the reason for that has mostly to do with the idea of a primary residence. So if someone is staying in a hotel, usually they have a primary residence to which they will return. However, if you have someone in transitional housing, say, where the stay may be shorter than a hotel stay for another person, fair housing will apply to that transitional housing stay because this person has no other primary residence. Uh, so I'll make note here as well of housing construction sites, homeowners associations, public housing authorities. These aren't physical locations. They're not dwellings as such, but fair housing law does still apply because they represent parts of that housing transaction to which fair housing law does still apply. Now, of course, there are some exemptions, and there are three classes of dwellings where fair housing laws don't apply, or parts of fair housing law don't apply. So sometimes the Fair Housing Act will make exemptions for housing operated by religious organizations. These exemptions apply only to the protected class of religion. Now, religious organizations are allowed to give preference to people of the same religion if the housing is non-commercial, that is not rented or operated for revenue or profit, and the religion itself does not discriminate based on other protected classes. For example, let's say a Catholic organization has an apartment building, they can legally limit occupancy or at least give preference to Catholic applicants if those apartments aren't being if the tenants aren't being charged rent and if the Catholic diocese in that area is not discriminating based on another protected class. And that discrimination based on another protected class generally applies to the sort of the adjacent religious organization exemption, which is a private club exemption, uh, which operates more or less the same. You also have the exemption class known as the Mrs. Murphy rule. This is owner occupied housing or smallholder housing. And so the Mrs. Murphy rule, as it's known, exempts smallholding housing owners from the fair housing laws completely. So federally, if a residence comprises 4 or fewer units and one of those units is presently occupied by the owner of those units or the owner's immediate family member, uh, that building would be exempt from fair housing law in general. Each state has its own version of the Mrs. Murphy rule, and Michigan's is further restrictive and reduces the residence to 2 or fewer units. And finally, we have senior designated housing or housing under the Housing for Older Persons Act, or HOPA. This falls into two categories. There's housing for people 55 years old and older, and housing for those 62 and older. In housing meant for persons 55 years old or older, pardon me, 80% of units need to be occupied by at least one person who is at least 55 years old. The terms, regulations, advertisements of that dwelling must clearly state their intent to operate as a dwelling designed for 55 years and older occupancy. And as you may be able to guess, once you hit 62 years and older, it's a little more restrictive. And in this case, 100% of those units must be occupied by at least one resident who is 62 years old or older. Now, in both cases, usually disabled people can live in either class of dwelling despite their age. And in both cases, further exemptions to that age criteria exist that often allow caretakers, and employees of the dwelling to live there regardless of their age. And I should be clear here that these HOPA units are exempt from fair housing laws that exempt, they are exemptions only to the protected class of familial status protections, which we'll get into just now. So I mentioned that there are 7 protected classes federally, and those are presented here in teal. And as I said, no state can limit these protections, but any state can add to them. And here in Michigan, the additional protected classes that apply most to housing are age and marital status. The controlling Michigan civil rights laws list more than just age and marital status as protected classes, but these extra protections apply usually to cases of employment instead of housing. So, for instance, weight is a protected class under Michigan disability laws, but weight discrimination is seldom an issue in fair housing cases. Most recently, Michigan added the protected class source of income, and that was signed into law in late 2024. We're coming up quickly on the 1-year anniversary of that passage. And I mentioned it a little earlier, but a quick note on language. Throughout this training, I'll be using both class and characteristic to refer to these protected classes. Protected classes is the language that's within the law, but it sometimes makes less sense or is more awkward to describe someone as being, say, in the class of families with children. So for our purposes today, both protected class and protected characteristic, sometimes protected person, will refer to these protected classes. So when we say that race is protected, that includes all races. Color refers to the color of one's skin. A darker skinned person of Indian origin is going to have the same rights as one with lighter skin. Religion includes one's membership or lack thereof in an organized religious group, as well as one's spiritual ideas or beliefs. National origin is the country where a person was born or the where from where one's ancestors come. And you'll notice here that under the federal classes, we have sex, and under the Michigan protected classes, we have sexual orientation, gender identity. This is a great instance of states being able to add to, but not take away from federally protected classes. Here in Michigan, sexual orientation and gender identity is a protected class, and it pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. And that includes one's relevant attitudes, preferences, beliefs, and practices of their gender, irrespective of its relation to their sex assigned at birth. Now, the sex assigned at birth is the only variable that is now protected federally. Familial status refers to the presence of one or more children under 18 in a household who is in a custodial relationship with an adult. And so that includes a parent, a step parent, an adoptive parent, a guardian, foster parent, et cetera, et cetera. A pregnant person or someone who is in the process of becoming pregnant, or someone who is in the process of acquiring legal custody of your child can also affect your family status protections. Pardon me. So disability is the most cited protected class in fair housing complaints, and we'll devote a little extra special attention to that at the end of this training. Marital status refers to someone who is single, married, separated, engaged, et cetera, et cetera. And in some jurisdictions, cohabitating. If you have a partner with whom you live, your particular arrangement, or not arrangement necessarily, but relationship to that person can't be used to discriminate against you in the housing transaction. Age refers to individuals of any age, and source of income, finally, means that a person who is seeking housing cannot be turned away or otherwise discriminated against in the housing transaction if part of their income comes from, for instance, supplemental security income or Section 8 vouchers. Now, each of these classes are protected by specific laws, and we're going to look now at a brief timeline of those laws. So, the protections afforded by fair housing were won over time. And this timeline is by no means comprehensive, but does provide a snapshot of those moments wherein protected classes with respect to housing were enshrined into law. Shortly after the end of the Civil War and the ratification of Amendments 13 and 14, newly freed slaves and native-born Black Americans are finally recognized as citizens. And the Civil Rights Act of 1866 details primarily the economic and property rights of these new citizens, including explicit protections against abridging those rights on the basis of race or color. It would take some time for those property, for those economic and property rights to explicitly include housing, but this is the first civil rights law passed in the United States that mentions protection based on race or color. So later in the mid 20th century, President Lyndon Baines Johnson is compelled to sign the Civil Rights Act of 1968. Organizations such as the NAACP and the GI Forum and the advocacy of people like Dr. Reverend Martin Luther King Jr. Were instrumental in adding national origin and religion protections to the CRA 1968. Now, Title 8 of the Civil Rights Act of 1968 is what's known as the Fair Housing Act. The Fair Housing Act would be amended further, first in 1974 to add sex as a protected class, and then again in 1988 to add family and disability status as protected classes. Alongside the federal fair housing laws, as I've mentioned, state and local governments will pass their own fair housing laws. And here in Michigan, our controlling civil rights law is the Elliott-Larsen Civil Rights Act, passed in 1975, and that adds marital status and age protections. In 2023, the Elliott-Larsen Civil Rights Act, or ELCRA, was amended to mirror an earlier executive order in the Biden administration, which added protections for all sexual orientations and gender identities. And last but certainly not least, on December 30th, 2024, Michigan Governor Gretchen Whitmer signed into law a bill package including Senate Bill 205, which adds fair housing protections based on source of income. So, pardon me. By adding source of income protections, a landlord can't discriminate if a tenant's income includes Section 8 housing choice vouchers, public assistance, veterans benefits, Social Security, supplemental security income, or other retirement programs, basically any legally derived non-employment source of income, now for the purposes of housing, counts as whole income in the state of Michigan. We joined 18 other states that had previously barred landlords from rejecting tenants solely based on their housing vouchers. And additionally, before the statewide passage, 16 Michigan cities had previously adopted ordinances around source of income discrimination. Pardon me. Now, we've talked a lot about someone's right to not be discriminated against. There are four forms of discriminations, or four forms of discrimination, or what's known as theories of discrimination. Those are discriminatory intent, disparate impact, retaliation, and failure to accommodate. And as I've mentioned, only behavior that involves one or more of the protected classes is illegal under the Fair Housing Act. So for example, let's say a Michigan landlord refuses to rent an apartment to a prospective tenant. They may not have in that violated the act, even though a covered practice and a covered property may be involved, unless it can also be shown that that landlord's refusal was based on a protected class like race, color, religion, etc. If the landlord's action was based on a non-protected factor, such as a prospect's bad credit, no violation of the act has occurred. However, the landlord in the example does not need to have done that on purpose or otherwise with discriminatory intent. The practice is prohibited even if it has a disparate impact in Michigan. That is, the practice can appear neutral, but because of how the protected classes intersect with reality, could have a disparate impact. And I'm going to get into this a little bit. There are some recent changes that I'll get into it in the recent changes here in just a moment. But in order to understand a disparate impact, consider the following hypothetical. Let's say that a property developer wants to build affordable housing specifically intended for occupation by nurses. Because career is not a protected class, that could be above board. People generally like nurses, so they may even be seen as noble and have good public perception behind it. However, in this developer's area, 95% of nurses are white. And so by attempting to limit access to the dwelling only to an area's nurses, this developer has unintentionally limited access based on race, which creates a disparate impact. And the disparate impact angle now is only valid at the state level. And again, these recent changes have affected how it's enforced. And as I've said, we'll get to that here in just a moment. Retaliation is the third theory of discrimination and is always out of bounds. So even when a complaint does not constitute an example of illegal housing discrimination, a retaliatory act such as raising the rent or withholding maintenance because of that complaint certainly is. And now finally, failure to accommodate is a housing provider's failure to allow reasonable accommodations or modifications that would better allow a disabled person to exercise their right to full use and enjoyment of their dwelling. This is one of the most common practices cited in fair housing complaints. And as I mentioned, we're going to spend a little extra time going over disability toward the end of this training. As I've mentioned, there are some recent changes. January 20th, 25, the federal protections for sexual orientation and gender identity were brought back to a previous level of just protecting biological sex or sex assigned at birth. And here, disparate impact is no longer a valid angle for investigating discrimination. This applies only at the federal level. However, on April 23rd, this invalidation existed only at the level of an executive order, redirecting enforcement efforts. However, recently, the Department of Justice issued a rule invalidating disparate impact theory of discrimination. And the center is going to work to provide more information on further changes to this disparate impact ruling to these protected classes as they occur. And I would like to briefly bring up this case, Alexander v. Sandoval in 2001. This is a Supreme Court case that established that there is no private right of action for a disparate impact discrimination claim. We're putting the cart above the horse a little bit here, but one of the methods for redressing discriminatory damages is private right of action, otherwise known as your right to sue. This Department of Justice ruling has stated that there will be no administrative complaint available to people who are bringing a case based on a disparate impact theory of discrimination. And so without the avenue of an administrative complaint and without the avenue of private right of action, while disparate impacts is still a state level valid angle of analysis for discrimination, it is no longer an enforceable, you cannot now bring enforcement based on this theory of discrimination. And so disparate impact has been rendered moot. And again, we'll bring more information on those changes as they come. So we've gone over these theories of discrimination, the protected classes, the laws that bring us these protected classes. What do they look like in practice? So we're going to go over now the sort of 4 categories that we find to be most common in categorizing housing discrimination. You have terms and conditions discrimination, you have steering, you have misrepresentation of availability, and then you have discriminatory statements. And we'll begin with terms and conditions, and this is probably the broadest group. So it is unlawful to offer or to impose different terms and conditions based on someone's protected class. So even when these terms and conditions may be seen by the person offering or imposing that difference as being a beneficial difference, the different treatment is in itself discriminatory. Excuse me. So if a prospective tenant who is white is given access to a portal showing all available rentals, but a prospective tenant who is black is not given access to that same portal, that would be terms and conditions discrimination based on the protected characteristic of race. If a tenant is asked to submit rent online after the Michigan-based housing provider learns that he is gay, when a person who isn't gay is still invited to come into the office to pay in person, this would be terms and conditions discrimination based on sexual orientation. Now, this person would be able to file a claim only with the Michigan Department of Civil Rights, and that would be an administrative complaint claim, because the MDCR, Michigan Department of Civil Rights, is a state organization. They would not now be able to file with Housing and Urban Development because it is a federal organization, and federally, their sexual orientation is no longer protected. So let's say that a landlord wants to charge a person with an apparent disability a higher security deposit, anticipating that they will need later to install grab bars or some other reasonable modification, or to offset, say this person uses a wheelchair, and the landlord wants to charge a higher security deposit to offset the increased wear and tear of a wheelchair kind of bumping into the generally more narrow than needed doorways, hallways, etc. Now, even if the tenant does need that modification, um, and the cost is paid by a housing provider, the asking for a higher security deposit in itself is a terms and conditions discrimination based on disability. Let's say that a landlord routinely sorts maintenance requests from women or to the bottom of the stack. That would be terms and conditions discrimination based on sex. And finally, if a landlord accepts housing choice vouchers but requires voucher holders to sign a waiver or limits access to certain accommodations within the building that other tenants don't have to sign or that other tenants have access to, that would be terms and conditions discrimination based on source of income. So steering is any attempt to segregate housing seekers based on their protected characteristics. It's broadly defined and it can be very wide or quite narrow in scope. So in the past, many local governments would have laws specifically forbidding integration of neighborhoods. These laws would prohibit Black people from moving into majority white neighborhoods and vice versa. And so this is, in effect, steering at its largest scale. At a smaller scale, a practice such as pushing prospective tenants to the rear of an apartment complex because these tenants have kids and, quote, lots of families live there, or that's where the playground is, where we have elderly residents near the road who complain about noise when there are families with children around. This would be steering. Um, Other examples would include suggesting to a Spanish-speaking home seeker that they would prefer this neighborhood instead of that neighborhood because this one has a church that holds Spanish language mass. This is steering. Um, Not allowing a person with an apparent mobility impairment to rent second floor apartments, that would also be steering. Um, excuse me. But not even showing to this person these second floor apartments is also you can also classify that as misrepresenting availability. And so while this is related to steering and that it has the effect of pushing people to certain zones, thereby segregating them, it is subtly different in that the housing isn't in the first place made available. And it is what it sounds like. You're telling people that there are not units available when there are. And this can be a difficult type of discrimination to identify because discovering that that unit is actually available tends to happen by accident. Now, as a reminder, it must be shown, it must be shown that the misrepresenting is related to a person's protected class. Not showing someone apartments that are out of their price range, for instance, would not be a misrepresentation of availability. If, however, here in Michigan, a prospective tenant is shown only those apartments that fit their income without supplemental income, like a Section 8 or housing choice voucher, that would be misrepresentation of availability because source of income is protected in Michigan. And finally, we have maybe the most recognizable type of discrimination, and this would be discriminatory state. So consider the example phrase at the bottom of the slide here. I can't stand magicians. Now, this could just be a weird quirk of the housing provider, entirely unrelated to someone's rights or their obligations under fair housing. If, however, they have a tenant who is Black and who also works as a magician, or as a magician as a hobby, it could be reasonably inferred that this is not only about the tenant's job or hobby. And this is especially true if one can identify a timeline. Did the landlord ever discuss this opinion before the tenant moved into the building? Does this opinion come out of the landlord, the more often they see this tenant. Discriminatory statements are, as I said, maybe the most recognizable type and generally one of the least common, as often people are a little more subtle. But this is a brief rundown of those common types of illegal housing practices. They could be related to any of the protected classes. However, the most cited protected class in fair housing complaints is disability. And we'll get into that a little bit now. So as I've said a couple of times, disability is consistently the most reported protected class at issue in fair housing claims. And it's not hard to see why. Anyone can find themselves living with a disability regardless of their race, color, religion, national origin, sex, or family status. And because of that special position among the protected classes, we take a look now at some of the facts related to disability and housing. So, what is a disability under fair housing law? A disability under the law is an impairment that substantially limits a major life activity. What is a major life activity? It's widely defined. Some of them include sleeping, walking, talking, bathing, driving, working. But a person can have an impairment that substantially limits a major life activity that would that fits the legal definition of a disability, but they also are afforded protections with disability as a protected class if they have a history of having that impairment, or if they're regarded or seen as having that impairment. So a person with a disability does not necessarily need to be disabled for these laws to apply. A person, as I've said, is protected with regards to their disability who does actively live with that impairment, who is perceived as having such an impairment, having had a history of having such an impairment, and disability laws also apply to people who associate with a so defined disabled person. And as I mentioned, a major life activity should be broadly construed. It's any impairment which limits or substantially changes by, say, requiring the use of a wheelchair or white cane, these major life activities. And a brief note before we go forward, disabilities are sometimes apparent, as in the case of the need of use of a wheelchair, but they're quite often non-apparent. And under fair housing law, all people have the right to full use and enjoyment of their home. And sometimes a person's disability may require that changes to either the rules or physical space of a dwelling be carried out to achieve this. And I bring up the apparent non-apparent split as it's important to the process one might go through to secure those changes. And as I mentioned, you might need changes to the rules. Changes to the rules, policies, procedures of a dwelling are what's known as a reasonable accommodation. And disallowing these reasonable accommodations or reasonable modifications, changes to the space, are what's known as a failure to accommodate, which you'll recognize as that fourth theory of discrimination from earlier. As of March 13th, 1991, following the passage of the Fair Housing Amendments Act of 1988, mentioned earlier as well, new multifamily dwellings need to be constructed with accessibility in mind. Now, of course, not all new construction is multifamily, nor is every dwelling occupied by a disabled person a post-1991 construction. Accessibility, then, is accomplished through reasonable accommodations, which are, again, changes to rules, policies, and procedures, or reasonable modifications, which are changes to the physical or informational space within a dwelling. Refusing to allow those modifications is a violation of fair housing law if those modifications or accommodations are deemed to be reasonable, which we'll get into. Excuse me. So we'll begin by talking about reasonable accommodations, then reasonable modifications. And finally, we'll talk a little bit about what constitutes reasonability, even though ultimately that is defined on a case-by-case basis. And it's if it goes far enough along without any mutual resolution, it is decided by a court. Now, a reasonable accommodation is a broad concept. What's needed and how it's provided depends on the circumstances. And crucially, it's the duty of a person with a disability to request that accommodation. They know their needs best. And so the idea is to assist that tenant achieve full use, assist them to achieve full use and enjoyment of their dwelling but not by placing an undue burden on the housing provider. And there are a number of rules and laws that govern what constitutes a truly accessible construction. And not all of these are necessary in, say, a single family house in which one disabled person lives. Excuse me. If they have a mobility impairment, for instance, that does not necessitate the use of a wheelchair, um, they may require the reasonable modification of the installation of a ramp, but they may not need so much modification as someone who does use a wheelchair, who might need to have the doorways widened, for instance. So again, it's up to the person living with the disability to request the accommodation that fits their needs best. Now, I mentioned earlier the distinction between apparent and non-apparent disabilities. It's unfortunate, but it is often true that non-apparent disabilities can be treated with more suspicion by housing providers. The need for a wheelchair is easier to demonstrate to a housing provider or an outside observer in general than the need for an animal that helps one manage their post-traumatic stress disorder, for example. And so reasonable accommodations are needed when, one, the person with a disability asks for them. Two, the reasonable accommodation helps them achieve full use and enjoyment of their dwelling. And three, the reasonable accommodation does not constitute an undue burden. Now, there's no standard catalog of accommodations. People have unique needs. Not every disability presents the same way or ends up in the same major life activity limiting symptoms. And so for that reason, it's the responsibility of a housing provider to listen to reasonable accommodation or modification requests in good faith and to not assume what that person may or may not need. And we'll talk a little bit more about that here in a moment. But here we've got a list of some of the reasonable accommodations that we've seen in our work. Pardon me. It may be appropriate to permit a tenant who has a mobility impairment to mail in their rental payment rather than paying in person. In cases where a rental agreement doesn't allow overnight guests, sometimes it can be reasonable to permit tenants with disabilities to have a 24-hour personal care assistant stay in their apartment. And in many, but not all places, this caregiver would be exempt to the rent requirements as they're not a tenant, but a worker. It'd be like charging a maintenance person rent for the time they spend fixing an air conditioning unit. Sometimes the number of accessible parking spots may be insufficient for every tenant who needs them or who could benefit from them if strictly allowed to do so on a first come, first served basis. From that, a reserved parking spot, usually one that lessens the distance or the number of obstacles between the spot and the dwelling, can help. Some people with disabilities may have little to no rental history because previously living with relatives or some sort of non-traditional arrangement, and then it might be appropriate for a housing provider to accept a reference from an employer, a social worker, a medical professional, a parent that this person lived with in lieu of a rental history. And finally, and this is a rather large one, is that even if there is a no pets policy, a disabled tenant must be allowed to keep a service or companion animal if they can provide food. And we have a second note on language here. Variously, I'll be referring to animals that help a person with the symptoms of their disability as a service, support, or companion animal. And because a person's disability does not exist only within the home, it's useful to maintain those distinctions while remembering that fair housing laws do not distinguish them. Now, service animals are defined by the Americans with Disabilities Act, and that maintains that separate definition, such as a seeing eye or leading dog for the visually impaired. And it maintains that separate definition to protect the use of that animal in public spaces. Now, the Fair Housing Act, because it applies to one's own home, the distinction is less relevant. It should be remembered, though, that the care that can be provided by an emotional support animal is no less important or therapeutic than that provided by a service animal. A service dog, as mentioned, can act as a leader for the visually impaired. They may act as stability aids. Others can open doors, fetch medicines, or smell oncoming seizures. Again, this list is not exhaustive. But emotional support animals, although they serve less visible functions, they are no less important. And these are functions such as reducing stress during an anxiety attack, distracting a person from or halting those self-destructive behaviors, bringing comfort during PTSD episodes, the list goes on. And so I bring that up to say that one of the most common accommodations that arises in fair housing is service support or companion animals as an exception to a no pets policy. And so when a tenant indicates a need for a service animal, the housing provider can, especially in the case of a non-apparent disability, request that the tenant provide a letter from a healthcare provider verifying that the tenant has a disability, which requires the presence of that animal to assist in symptoms of that disability. Now, a healthcare provider is not necessarily a degree holding nurse or doctor. It can be the person who's giving you healthcare the most in your life. And again, this is a case by case basis. Now, courts have ruled that there's no particular licensing or certification for service animals. Another way to say that is that licensing or certification is not required, so long as that the tenant demonstrates that the animal provides necessary assistance, often through this letter from a provider. And importantly, a housing provider cannot inquire specifically about the disability that this person has or the services that the animal provides. It is sufficient to say that the animal provides some care toward a symptom of this disability that affects major life activities. And now, while many support animals are dogs, they can be any type of animal. They don't need to wear any special harness or tag. They don't need to have any special certification or licensing. And on the tail of this, because they don't need to have any special certification or licensing, simply having a certificate or a license is not sufficient. In a few cases, an individual with a disability may even require more than one support animal. All that's required there is that there be what's called a nexus of care between the animal and the disability. That is, the animal provides some function that alleviates the symptoms of this disability. All that said, these animals are always subject to safety and hygiene standards. That animal cannot abridge this person's neighbor's rights to the full use and enjoyment of their home. So, support animals are a reasonable accommodation in that the housing provider accommodates the tenant by waiving a no pets policy to allow the presence of that animal or animals in the home. However, sometimes what's needed is not an accommodation, but a modification. And again, these are alterations to the physical or informational space of a dwelling that may assist a tenant in navigating that space. So grab bars to help with stability and slippery surfaces, such as a shower, ramps to facilitate wheeled travel, flashing lights instead of a doorbell for a person who lives with a hearing impairment is a common example of a modification that changes the information available to this person. As with pretty much any list I've given in this training, it's not exhaustive, and it's up to the person with an impairment to determine what modifications suit their needs. Other examples of modifications include widened doorways for wheelchair travel, zero-step showers instead of a high bathtub wall, reinforcements to the studs of a wall for the later installation of a grab bar. These are all common examples of modifications. Now, of course, it's usually very inexpensive or even free to adjust rules and regulations for reasonable accommodation. But if you're going to build a ramp, it's going to require time, labor, and materials. And these all have costs, and these costs add up. So where does the money come from? So usually a tenant is expected to cover the expenses of making a reasonable modification, unless those modifications also benefit the whole building. And while changing the rules to allow a reserved parking spot costs nothing, the printing and installation of that sign that designates the spot as reserved, that does have a cost, and the tenant may be required to cover those costs. And this is the case in privately owned housing, but in the case of subsidized housing, such as housing choice voucher or Section 8 subsidized, a dwelling subsidized under a Rule 515 program, certain cases of low-income housing tax credits, the housing provider is required or is at a greater obligation to cover these costs. Now, to save money on a modification, a tenant may offer to accomplish that modification themselves. and a housing provider has the right to insist that a professional install that modification. Wear and tear is defined as the expected deterioration that would occur over time, which is to say that its dispute is on a case by case basis. And finally, this last bullet point, a tenant does not have to undo neutral changes. A neutral change refers to changes that do not impact any later tenant's ability to fully use and enjoy that dwelling. So a doorway that is widened for wheelchair use does not then need to be narrowed at the end of tenancy. It's perfectly acceptable to, during the agreement, to allow the installation of a grab bar, for part of that agreement to be the uninstallation of the grab bar at the end of tenancy. But if a wall has to be reinforced in order to add that grab bar, you don't need to pull the reinforcement out. It's not getting in the way of the next tenant. So, what does reasonable mean? And this is, is a question without a single clean answer, but there are situations when the accommodation or modification has been requested as not reasonable. Sometimes it amounts to an undue burden. That means that in the context of a provider's total financial or administrative costs, the accommodation is too costly. A request can constitute a fundamental alteration when an accommodation would cause the housing providers to change the way they do business, or where what's requested goes above and beyond what is normally provided. So, for example, an unreasonable accommodation may be that a tenant who lives with a chemical sensitivity disorder, that tenant has requested that the owner survey all tenants of the building to determine the time of day and the chemicals they will use to clean their units. They ask that the owner then compile this information for them on a weekly basis so that they can plan to be away from their unit at the time that certain chemicals are used. This is on its face a pretty high administrative burden that may easily be seen as constituting an undue administrative burden, therefore be unreasonable. An unreasonable modification could be requesting the installation of a motorized chairlift where a ramp would suffice. If your reasonable accommodation while living in senior designated houses is that you be allowed to live with 6 of your grandchildren, that could be seen as invalidating the terms of the program in that it is housing intended for older persons. However, in all cases where an accommodation or modification is deemed by a housing provider to be unreasonable, it is their duty to work with the tenant to try to find a more reasonable solution. I'll point now at another court case just to underscore this. In Jankowski Lee v. Cisneros in 1996, the tenant suffers a mobility disability stemming from their multiple sclerosis diagnosis. Within the case, the defendants talk about sometimes seeing them walk from their car with no real problem. The reasonable accommodation at issue was a reserved parking spot. But the circuit court Judge Eschbach, delivering the majority opinion, says petitioner's denial of Rusinov's request based on their lack of knowledge of the extent of his injury is simply a ruse to avoid the penalty for violating the FHA. This emphasis is mine. If a landlord is skeptical of a tenant's alleged disability to provide an accommodation, it is incumbent upon the landlord to request documentation or to open a dialogue. And that requesting documentation only to the extent that this shows the need for the accommodation. And as I said, I've included this to underscore that reasonable accommodation and modification requests should always be viewed by the housing provider in the best possible light of a tenant's request. It bears repeating that a tenant knows their disability and therefore their own needs related to that disability better than anyone. And if there is doubt as to the severity of a disability or the reasonableness of accommodation, it is the landlord's responsibility under the Fair Housing Act to be proactive in finding a solution that meets both the needs of the tenant and the reasonability of the realities of their business. And now there is finally a very limited exemption case to disability protections, and that is the direct threat exemption. So in limited cases, a person's fair housing rights may be abridged if they present or can be reasonably construed to present a direct threat to others. So recall that all residents are afforded the right to full use and enjoyment of their dwelling. A direct threat exemption to disability protections exists when a person may compromise their neighbor's rights in this regard. It's it's an exceedingly rare exemption class, and it must be very carefully considered. The nature, duration, and severity of the risk must be taken into account, the probability that injury will occur. And finally, and this I think is the most important part of this consideration, is can a reasonable accommodation or reasonable accommodations be put into place to mitigate the potential risk? So we're going to turn now to, and I'm sorry, I'm going to pick up the pace a little bit here, some other housing issues that aren't necessarily protected by fair housing, but are coincident with certain protected classes. And we'll talk about criminal records and occupancy standards. So having a criminal record is not yet a protected characteristic, but it often does intersect with other protected characteristics. And so for this reason, certain approaches to criminal background screening can be discriminatory, and this would be disallowed by fair housing law here in Michigan. So the best practices for dealing with these criminal records are to do case-by-case reviews, give an applicant a chance to explain this record, to remain mindful and avoid biases, and to run Fair Credit Reporting Act compliant background checks. And there are some cases where a blanket ban on criminal records are acceptable, and that is crimes of dishonesty, of which narcotics manufacture falls under that category, as well as any crime that ends with a lifetime sexual offense registration. It's acceptable to say, no, don't even need to consider the other facts of the case. We also have occupancy standards that are determined by local governments. And there are no hard rules on what determines occupancy standards at the municipal level, but typically they're related to overall size of unit, the configuration of a unit. A 10 by 10 by 10 room does not have the same occupancy standard as that same dimension, but with a slanted roof. Then septic, sewer, and other municipal resources, the capacity in that area can also determine the occupancy standards for a dwelling. And it's been some time since there's been an update on this guideline, but generally 2 people per bedroom plus 1 extra person is an acceptable occupancy rate. So if you have a 3-bedroom house, then you can have 7 people in it without abridging that guideline. So that was a lot. But what are some best practices to avoid discriminating in the first place, or to recognize discrimination and how to deal with it? So as a landlord or housing professional, you should treat all applicants fairly, equally, and honestly. Follow the same application and screening processes for every applicant. Never tell an applicant that a dwelling for rent is not available when one is, and tell applicants about all available units that fit their price range, that they're able to make a bona fide offer on. A fair housing adherent provider will treat everyone the same, allow housing seekers to make their own choices, and make decisions based on an applicant's behavior and not their characteristics. And at the end of the day, these are also just good business practices. And so if you do find yourself having a fair housing complaint, or you think you or someone you know is going through housing discrimination, first and foremost, reach out to your Fair Housing Center. Obviously, that's us in Southwest Michigan. But we can help you to draft an administrative complaint. There are federal as well as state agencies to direct these to. We can help draft reasonable accommodation requests. You also have the right to private action or a civil lawsuit. Speaking with a Fair Housing Center can help you get in contact with attorneys. That, I believe, takes us to the end of this presentation. We have a couple of resources. There's the Fair Housing Act as amended, passed in 1988. That is the most recent and largest change to the federal fair housing law. You have the Elliott Larson Civil Rights Act here in Michigan, and I personally use the website Justia to look up legal cases, to look if you've got questions, has this ever happened to me, or what do I do in this case? that can be a great resource to see if someone else has gone through something similar. There's also the Legal Momentum is a similar website. And finally, the Landlord Tenant Guidebook is something that we have here in Southwest Michigan that outlines a lot of what you should expect and what you should uh, not stand for in terms of the housing transaction. It's a good guidebook as to your rights and responsibilities under fair housing. So I'd like to thank you again for attending. And I'm going to leave it here on this screen with our contact information before I stop this recording and open the floor to questions.